Hi, everyone. I'm Patrick Best. I'm a Social Security disability attorney at ARM Lawyers. Today, we're going to be talking about what to expect at your Social Security disability hearing. I'm going to do some similar videos here about how to prepare for your hearing, as well as how to testify at your hearing or what sort of questions to expect. So we're not going to cover that in today's video, but I will put the links in the description. So if you have any questions about those, feel free to click below. But for now, I want to talk to you about what to expect at the hearing. So from the time you walk in, you are going to walk in almost every case into a room with a security. You're either going to have to go through the metal detector, or you're going to have to meet with a security guard who's going to have a metal detecting wand. They may go through your bags. They're going to make sure that you don't have anything like a gun or a pocket knife or anything that would be impermissible in a federal facility. So if you have any of that stuff and you normally carry it with you, please don't. Please don't bring it with you to the hearing. It makes everything more complicated. They will make you take it outside. So please don't bring that with you. After you go through security, you're going to have to go to the window and check in with whoever is doing the check-ins. In some cases, that's actually the security guard themselves, and in some cases, that's a Social Security employee. They are going to check your ID, so please bring photo ID with you just to make sure that the name on the ID matches the name of the person who's having the hearing. Sometimes I've had clients who have not brought their ID with them, and they've actually had their hearings rescheduled, so please make sure you bring that with you. After you check in, you're going to be seated in a waiting room. And again, it varies from location to location what this room looks like, but in most cases, they're relatively small rooms with a number of seats for people who are waiting for their hearing. Some days, those hearing rooms are packed. Some days they are not. It all depends on how many judges are there, how many hearings they have that day, but chances are you're going to be there with at least some people. Be very careful about what you say in the waiting room, because while everyone's there for a hearing, sometimes the Social Security employees like to listen and like to report to the judges things that they hear. It may sound like it's not a big deal to you, but again, sometimes judges will use that information to try to deny you. So please be very careful about that. If you need to talk to your attorney or your representative, almost every hearing room has a conference room for you to talk privately with your attorney. So I would encourage you, if you want to have a discussion, please use those rooms if possible. After you are ready to be called, so your judge is ready for you, the hearing reporter is going to come and get you and bring you back to the hearing room. The hearing room is a very small conference room. Again, very informal setting here. It's not a courtroom. Normally, it's just a small room with a table. There's going to be a few people in there with you. It'll be you, your attorney, your representative, the hearing reporter, whose job is to just record the hearing, to make sure that it's saved in case there's an appeal, the judge, and in some cases, you're going to have other witnesses. They may be a vocational expert, it may be a medical expert. It really depends on your particular case. That's not always the case for individual people. Sometimes they're there, sometimes they're not. Sometimes they're participating by phone, sometimes they're not. Your attorney would be able to tell you whether or not those people are going to be present for your case. In terms of whether or not you're able to bring family members into the room, every judge is different. I would say normally the judges that I appear in front of on a regular basis don't like other family members being there. There are certain cases in which that may be different. Obviously, I've had cases with clients who've had wheelchairs where we've had to have family members escort them into the hearing room. But in most cases, the judges that I frequent typically don't allow family members to be in the room. Again, it's case by case. You could certainly ask your attorney. Once you are in the hearing room and you are seated, the judge will start the proceedings. The judge will say on the record, which means that the recording has started. Normally, the judge will go over some preliminary matters with your attorney, if you have one, and then swear you in. Just ask you to raise your right hand, ask you if you swear to tell the truth. Judge will do that with other witnesses as well. So if there's a vocational expert or medical expert there, those people will be sworn in at the same time. If you have an attorney, the judge will ask the attorney to make an opening statement. That's your attorney's time to explain to the judge why you're disabled. And again, I don't want to make this complex, but when we say that, it's not as simple as tell me about the medical conditions that are at play here. We're using very coded language referring back to the statute, the regulations, or the rulings from Social Security that point out that you are disabled. So it's not going to be as simple as saying, Mr. Jones has a herniated disc that prevents him from working. That's not going to cut it. You're going to hear far more specific language from your attorney. That's why it's important to have an attorney, because they're going to be able to explain to the judge using very technical terms why it is that you meet the stringent requirement for disability under the Social Security Act. After the opening statement, the judge will typically move to testimony. Some judges will want to question you themselves. Some judges will want your attorney to question you, and most will want both. They'll start by questioning themselves on some preliminary matters and then allow your attorney to follow up with anything that they want to ask. I would say that, again, the questions that are going to be asked can vary from case to case. I'm going to do a whole other video on the questions that are going to be asked. So for now, we're going to pass over that, and let's just say that you're going to have to testify about the nature of your impairments and your conditions, as well as maybe your work history. After you testify, the judge will have other witnesses testify, whether that be a medical expert or vocational expert if relevant to your case. If either of those are going to testify, your attorney will have an opportunity to cross-examine them, meaning ask them questions that may change their answers or lead the judge to maybe a different conclusion. After all of the witnesses have testified, the judge will ordinarily give the attorney or you an opportunity to give a closing argument or just say anything else that is relevant and go off the record. Simply means that we're no longer recording and the case is closed. In most cases, that means the judge is going to go make a decision. In some cases, it means that the judge is going to reschedule the hearing. Maybe some evidence was missing, maybe we need another witness, maybe just some other reason the judge can't make the decision yet. But if the case is closed, it'll go to decision writing. The judge will make the decision. The decision writing time can vary. I'm always hesitant to answer my clients' questions when they say, how long? Because honestly, I don't know. I would normally say 2 to 4 months. Lately, it's been more like 4 to 6 months. It does depend on hearing office to hearing office. It does depend judge to judge. Time of the year matters, because are they on vacation? It matters whether or not we have a government shutdown or something like that that would slow the process down. So it's very difficult for me to tell you exactly how much time that's going to take. Be patient. It does take time for those decisions to be written. If you win, that decision will be sent to the payment center and processed for a notice of award and payment. If you lose, you will get an unfavorable decision in the mail. Your attorney, if you had one, would get a copy as well. You do have appeal rights from that decision, so you're going to want to review that with your attorney. You have an opportunity in most cases to appeal within 60 days to the appeals council, and if you lose at that level, to appeal to the federal district court. Again, I'll do some other videos on those topics because both the appeals council and the federal court are a little bit more detailed than we're going to cover here. So suffice it to say that you do have appeal rights. Feel free to discuss those with your attorney. Thank you for joining us today. If you have any questions, please feel free to either contact us using the link below. Happy to answer any questions anytime. You can also just put a comment below. If it's a general question, I'm happy to do a video on it. We're making new videos all the time, so please make sure to do that. Like the video if you found it was helpful. Share it with anyone who you believe needs to hear this information, and subscribe to our channel. If you want up-to-date information on all things legal, subscribe and get all the latest information. Thanks again for joining us. We'll see you next time.